Hey everyone, hope everyone's doing well. Um, Last time we talked about why estate planning is important. Today I want to talk a little bit about what happens if you don't have an estate plan. What are the ramifications of you not having an estate plan? So what I've done is I've kind of made some notes here. And if you don't have an estate plan, if you don't have a will in place, if you don't have a trust in place, you're subjecting yourself and your family to what we call living probate. All right. A lot of people have heard of the term probate, and they associate it with, well, probate when I pass away, having a will probated, or having my estate probated. And those are legitimate concerns, but there's also what we call living probate. And living probate is the establishment of guardianship and or conservatorship in the event that you either become incapacitated or you are a person in need of protection. So if you happen to have a debilitating illness, you get a debilitating illness, if you happen to have heaven forbid, a stroke or a heart attack, or involved in an accident where you have a traumatic brain injury or something along those lines, someone would need to petition the court to become your guardian and or conservator to help you make medical decisions, to help manage your money. So that is called living probate, okay? And the thing about living probate is the Code of Alabama dictates as who can be appointed your guardian, who can be appointed your conservator. They must be a resident of the state in which you live. So if you live, let's say, in Alabama, and all of your children live outside of the state, none of your children can serve as your guardian and or conservator. All right. Someone from this who is a resident of the state has to be appointed by the probate judge. So, exactly what does a guardian do? A guardian, like I said, makes decisions or helps make decisions regarding your health, maintenance, and support. What does a conservator do? A conservator helps manage your money, pay your bills, make sure that you're financially taken care of. And a conservator, on top of that, has to post a bond, and they have to do accountings on a regular basis with the probate court. So, once the probate court is involved in your life, they're generally involved for the rest of your life. So everything becomes public in living probate. Your guardian has to file paperwork with the court on a regular basis saying, where you are, how you're doing, basically giving a report to the court of your condition. And the reason for that is they want to make sure that the guardian is doing what they're supposed to do and taking care of you. And like I said, the conservator is going to wind up having to post a bond and file accountings with the courts. So they have to account for all of the money that comes into your estate and all the money they're paying out on your behalf. Okay, so everything becomes public. Anybody can go down there and see what's going on with your business. So if you don't have an estate plan in place, you're subjecting yourself and your family to that very public process of living probate. Then when you pass away, your estate has to be probated. And really probate is the only way that we can transfer title from your name to your heirs' names. And the probate process, if you don't have an estate plan, is codified in the probate code. The probate code dictates the process, the judge makes rulings on the process, and the state dictates who receives your assets and when they receive them. So you have no control over the process. You have no control over who gets what or when they get it. So, and again, this is a very public process. You have to hire an attorney. Paperwork has to be filed with the court. It is a very time-consuming process. In the state of Alabama, you have what we call a 6-month non-claims period, where your estate is frozen for 6 months. The entire process from A to Z can last anywhere from 9 months on further. So it's a very time-consuming process. It's a very public process. Again, the state controls the process. The judge makes the rulings on the process, and the judge makes a ruling as who is in control of the process, who is going to be your personal representative, who is going to manage all this, who's going to do all this for you. So, so if you don't have an estate plan in place, just to recap, number one, you're subjecting yourself and your family to living probate, which is guardianships and conservatorships. And number two, you're subjecting your family and your heirs to probate when you pass away. And the state is going to control the process. The state is going to control who gets what you have and when they get it. So if you're thinking about an estate plan, if you don't have an estate plan in place, or if you're thinking about doing an estate plan, or maybe you have a will and you're thinking about redoing your will, you can give us a call in the Dothan office at 334-792-6213, or in the Fairhope office at 251-333-9371. And we'll give you a free 15-minute consultation. You'll either talk to myself or you'll talk to my paralegal. We want to give you a free 15-minute consultation on the estate planning process, okay, and getting your estate plan put in place. So again, give us a call if you're thinking about doing that. If you have any just general questions, you can send us an email. You can visit our website and send us an email through our website, or you can message us here on Facebook. We'll be glad to answer any questions that you have if you want to make contact with us that way. So it's, just feel free to reach out to us. We're here to serve you. Next time, what we want to talk about is what should a basic estate plan accomplish? Okay, what are some of the things that we're wanting to do when we do our estate plan? So we're going to talk about that next time. So until then, everyone stay safe, and we'll talk to you next time.